something about the summer I turned pretty or something.
Sure.
Oh, is it a TV show?
It's like a good guy, and then the other one is kind of like a bad boy.
But here's the thing.
Oh,
I have understanding now that somebody's told me they're brothers, right?
Yeah.
oh,
Hey, let me just tell you, my mom would have put a stop to that nonsense real quick. She would have like, excuse me, this is the summer you turn pretty, but my sons are not
and
competing.
stayed at home. Did you watch Hunting Wives?
No, I haven't seen.
You
Okay,
gotta watch it.
all right, that's on my list.
It is that Hunting Wives. You have to watch it alone. Don't watch it in public.
And here, like, what are you all talking about?
Sorry. TV show. Sorry.
I will tell you, one time I went as a defense attorney because I would always go see my clients at the jail. I would try to see them once a week, and I would ride the via bus. So I would ride the via bus to the courthouse. And then once I finished at the courthouse, I would walk to the Bear
All the
County
way to
jail.
the jail.
Yes.
Wow.
Oh, it was fine. So I would walk there, and there was a bondsman office that was right on the corner. And so it would take $1 to get a soda. And they'd be like, Stephanie, for you, it's free. I'm like, oh, thanks.
Yeah.
And then I would go see my clients. And so when you're a defense attorney, you have all these clients you have to see. And then some of my clients, their family would never visit them. So you're the only person they see.
Mhm.
So sometimes you would end up, I'll never forget my client. He was asking me, how was Godzilla? That's how long ago since it's been since I
The
was
movie.
there. And it was the one with, what is his name? The guy who played in Ferris Bueller's Day Off.
Matthew Broderick.
And I'm sitting there and I'm like, I can't believe my client is here. He has a serious case and he wants to know what happened in Godzilla. So we talked. So hopefully, you know that your attorney is 100% focused on your case.
Yes.
But sometimes it helps when you talk about other things,
Yes, ma'am.
so that people can realize there's still humanity out there. All right.
Yes, ma'am.
Okay.
I used to watch Netflix with my wife and my kids.
Oh, what was one of your favorite shows?
And
That one and
Did y'all do Wednesday?
the children.
no.
Don't tell me you're doing Walking Dead and you're like, well, my 3-year-old and I were walking.
Oh gosh.
There's some other shows like that for my kids that I would watch with them. I don't remember the names.
I will tell you, growing up, I now have to tell my mom, I'm so sorry you were watching Hey Arnold
Oh, I remember that cartoon.
and then SpongeBob SquarePants. I'm like, I'm sorry, Mom.
That's a legend, a classic.
All right, we're going to go on the record in 2025 CR 004541 and 2025 CR 0.
And here it begins, the moment where the stakes become real. Notice how Judge Boyd carefully confirms discovery, indictments, and rights with the defendant. This isn't small talk, it's ritual. Every question locks in the record. Every yes, ma'am, is a chain tightening around his future. Think about it. Would you be calm enough to answer these questions knowing a prison term is on the table? This is where justice is less about drama and more about precision. Every word matters.
CR 004546, State versus Rodolfo Brasino III. Can I have parties announced?
Lauren Espinosa for the state.
Lauren Lefton for Mr. Briseno.
And are you Mr. Brasino?
Right.
Counsel, you received all discovery?
Yes, Your Honor.
And did you review it with your client?
Yes, Your Honor.
And each cause number, the court will find that the state is in compliance with discovery. Oh, thank you. And each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
State in each cause number, are you proceeding on the indictment as presented?
Yes, Your Honor.
And each cause number, did you review the court admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, sir.
And each cause number, you're charged with theft of property, $2,500 or more with 2 previous convictions. Those are state jail felonies. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each case, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent. To understand by entering into these plea bargain agreements, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each of the cause numbers?
Oh, yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor.
Mr. Rosinho, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand by entering into plea bargain agreements in each of these cause numbers, if for any reason it's declared that you are not a U.S. citizen, you can be deported, not allowed to re-enter the United States, and denied naturalization?
Yes, ma'am.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
All right. According to your plea bargain agreement, there's a $1,000 fine. The cases are to run concurrently. Punishment is to be assessed at 11 months in the state jail facility. State will take in consideration 2025 PF 11592, and there are no applications. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then in the cause number ended in 4-1, how do you plea?
No contest.
And the cause number ended in 4-6, how do you plea?
No contest.
State in each cause number, is there any evidence to support the defendant's plea?
Yes, Your Honor. In both cases, state offers would have been marked as State's Exhibit 1 and all attached.
No objections, Your Honor.
In each of the cause numbers, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and judgments? But most importantly, there will be no live testimony. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes.
No.
Oh,
Okay. All right. In each cause number, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to
This
find.
is where the emotional hammer drops. The judge doesn't just see a thief. She sees a father, a son, and a legacy tied to a family name. Her line, "You're ruining the name," isn't courtroom jargon, it's a dagger to the heart. And she's right. Every decision in that courtroom is bigger than him. It trickles down to children who didn't ask for this baggage. Here's the real question for you watching. Should a judge weigh legacy and family shame when handing down justice? Or stick purely to the law?
Evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. We ask you follow the agreement.
All right. Why do you keep stealing?
that was a backtrack for me.
Hmm?
That was a backtrack for me. I was staying at a motel. I needed some money. But then after that, I started going to school.
So here's the thing. Do you have children?
Yes, ma'am.
And what are their ages?
18, 13, 4, 3, and 1.
All right. So your last name is Briceño III. So that means that there was a second and there was a first. So do you have any relationship with Briceño Jr. and Briceño Sr.?
My grandpa passed away. My dad is.
All right. And were they good parents and a good grandfather?
Yes.
You're ruining the name. And then if you have a son, is he the fourth?
Yes.
You're ruining the name for him. Now, your son has all this baggage that they're going to have to try to repair this name. And can you imagine if everybody in this courtroom fell on hard times and our answer to falling on hard times was to go to stores and start stealing? That's what you're doing. And there are plenty of places, and I see part of the things that you were taking were baby formula, diapers, but there are plenty of places where you can get free baby formula.
This moment hit me hard. On the surface, stealing diapers and baby formula feels sympathetic. Who wouldn't feel compassion for a struggling parent? But Judge Boyd cut straight to the uncomfortable truth. Resources exist. Help exists. But he chose theft. That's the razor's edge between survival and crime. This is where moral gray areas twist us inside out. If you were in his shoes, desperate and broke, would you still resist stealing to feed your kids? Drop your verdict in the comments, because that's the question hanging heavy over this case.
Free baby formula, get free diapers. You don't have to go in and steal. And then the other thing is, people want to be fruitful and multiply, fine. But you have to start thinking children are expensive. So how am I going to pay for daycare if I'm going to work or if the mother has to work? Instead of just saying, oh, my dad will watch them or my mother will watch them because nobody asked them. You understand?
Yes, ma'am.
Children are expensive. You got to pay for diapers. And in your situation, if you can't afford diapers, you know what you should have done? I can't afford diapers, so I'm going to go the cloth route. But nobody wants to do cloth diapers. You know why? Because it's not convenient. It's extra work because then you got to wash them. You understand? You're going to have to start making better decisions. Otherwise, when you wake up, that 1-year-old is probably going to be 3 or 4 and doesn't even recognize you. And do not let them bring the children to the Bexar County Jail to meet with you. You just heard me say how nasty the jail is. Do not have them coming to visit you at the state jail facility. It's nasty, it's filthy, and you don't want your children to get in the habit of thinking seeing dad behind bars is okay and that's a nice place to be. You understand?
Yes, ma'am.
All right. And each cause number, as previously stated, the court is finding you guilty. And the cause number ending in 46, the court will sentence you to 11 months in the state jail facility. Give you credit for any time served. This is right concurrent with 2025 CR 004541. Take in consideration 2025 PF 11592. And in cause number ending in 41, court will sentence you to 11 months in the state jail facility. There's $1,000 fine. Time and money will run concurrently. This will run concurrent with 2025 CR 004546. Taking consideration 2025 PF 11592. Is there anything else with regards to sentencing in either of those cases?
No, Your Honor.
All right. In each of the cases, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. Good luck to you, sir.
And just so the court knows, these cases were about a year old, and since then he did enroll in cosmetology school and so he is aspiring to do better, and hopefully when he's released he'll be able to finish that education. So he is trying.
Usually males do very well in cosmetology school.
Yeah.
That's who you go to for a good haircut. Exactly. If you're female, I'm just saying.
Yeah, it's true. So hopefully this doesn't derail you totally when you start.
No, I'm looking forward to getting done and finishing to get my license.
Yeah.
All right. So let me explain something about getting your license. Both of these cases are what's called crimes of moral turpitude. So when you try to get your license, this is going to pop up. But it's not impossible for you to get your license, but you just cause an impairment to that, right? But there is someone who graduated from felony drug court, and everybody was telling them, you can't be an attorney. I'm sorry, that dream is dead for you because of all your past. And guess what? He has his license. He's an attorney. It just took him extra steps to do it, and he had extra things to prove to people. So it's not impossible, but you're going to have to do extra steps. You're going to have to get letters from people and show that you changed. You understand?
Yes, ma'am.
All right. Good luck to you.
Good luck.
Thanks, ma'am.
Here's this.
That's it, yeah.
Oh, thank you. God bless you too.
He's a nice guy. So I went to a CLE on Saturday where the TLAP attorney spoke. And he told, I mean, this was wild.
Oh, yeah, it is, right?
Yeah, but he told his own story, which is in 1990, he picked up an ag assault on a public servant for pulling a gun on a process server.
Yeah.
And that's when TLAP apparently stepped in for him, helped him get into rehab, and he's still a lawyer.
Okay, let me just tell you.
Mind blowing.
This is something about being an attorney.
I'm ready to go. Get it.
A lot of things are forgivable, but one thing that usually they don't forgive and you get disbarred, if you commingle funds with your client, or if you take your client's money, or if you don't stay in contact with your client. So those are the three things you should always do.
Well, I was going to say lying to the bar.
Yes.
That's a big no.
Oh, yeah, that is. And if they said something for a hearing, show up.
Yes.
You know that attorney like 20 years ago, I can't think of his name. He was very good looking, and he took his funds out of his account. What's it called, guys?
Yeah.
He spent it all. It was like $100,000 and committed suicide. Do you remember him?
No, I don't.
Do you know anyone?
Kendall County just indicted an attorney for either commingling or taking funds. It sounds nice. Yeah.
Oh.
I hate taking money.
So when you say people feel like people are pregnant, is that just your argument? Yes.
Thank y'all for your time.
All right, thank you. Have a good one.
I think they're going to
On driving, it's third down.
Yes.
So this is
All right, Counsel Andrade?
Yes, Judge.
Yes.
It's a discovery hearing. I had asked Jason to view a video. The video was obtained. I believe we have all evidence. I was able to show a video to my client. Jason tendered an offer. We're respectfully asking if we can come back tomorrow or Wednesday. Jason put a expiration since he'll be leaving this court. He just wants to make a couple phone calls from the jail.
All right, Ms. Ferguson.
Oh.
Yes, ma'am. We can bring you back tomorrow. Norma, on Andrade?
Yes, sir.
Tomorrow. I know.
It's kind of late, Judge, and we already submitted the thing.
Oh, just tell
Wednesday.
them.
Wednesday or Friday is better.
Thursday.
I can't do Thursday.
It'll have to be tomorrow.
Tomorrow.
Yeah. We can order them in the morning, whatever. Okay. All right. Thank you.
Thank you.
Yeah. Oh,
Thursday,
when we're done.
Hey, now, Danny Williams.
Andrade, come on.
Danny Williams. Could somebody make an announcement for Danny Williams? In the hallway. And Norma, that's on page 5. Where's his attorney?
This is back when it's so tiny. So let's see the cowboy.
Danny Ray Williams.
Oh, I have no idea.
Yeah. All right, we're going to go on the record in 2025 CR 008393 State versus Danny Ray Williams for the state. All right, this hearing was scheduled at 9 a.m. It is now 3:32 a.m. The defendant has not made an appearance. Request from the state.
Bond virtue or judge's warrant?
Judge's warrant. The court will grant a judge's warrant, remand the defendant without bond. If the defendant makes an appearance, the court will reconsider. All right, the court is calling 2025 CR 008497 State versus Manuel Rodriguez. Could I have parties announce?
Tony Hernandez on behalf of Mr. Rodriguez.
And are you Mr. Rodriguez?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
We have them.
Court will find that the state is in compliance with discovery. Ms. Abrams, this is an application. Mr. Rodriguez, did you review the application for community supervision with your attorney? Did you understand it? Did you sign it?
Yes.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We have, Your Honor.
Mr. Rodriguez, did you review the court admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places? You're charged with driving while intoxicated third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand by entering a plea to this cause, you could be deported or not allowed re-entry into the United States or naturalization if it's determined that you are not a citizen? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's a $2,000 fine. There's no application for deferred adjudication. The state would oppose your application for deferred adjudication if there were one. And the state recommends community supervision. And there's to be $60 to DPS for testing. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
And did you sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 200 hours of community service restitution, and VIP live. Did you understand those were recommendations from the state?
Yes.
And the court does not have to follow those recommendations.
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
No objections, Your Honor.
All right. And state, with regards to jail time, do you have any objections to GPS as opposed to jail time?
No.
All right. Thank you, state. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of written witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Please, Your Honor.
Anything that you wish to say on behalf of your client?
Your Honor, I would point out that this case has been pending for quite a while, and he's had no violations that I've come across indicating that he's in any way violating the admission interlock order. He's also been on monitor since released on bond for some apparent reason, and he has no violations on that either. We would ask the court he is working full time. He does stocking for, is it Walmart? Sam's, I'm sorry. Sam's Club, and he is employed full time. We would ask the court to follow the agreement.
All right. So do you have any children?
I have a boy. He's 24.
Okay. Any grandchildren?
I don't know. Not that I know.
Hopefully, he would tell you.
Yes, I hope.
Yeah. All right. So it's obvious to the court that you have an alcohol problem because you're here for your third DWI. You're one of those people who cannot drink at all. I don't know anybody that I've ever represented, and probably counsel anybody that you've ever represented who will say, you know what? After I get off at work, I'm going to go have a meal and I'm going to drink myself to intoxication, then drive and kill somebody. Nobody ever, have you ever had anybody to say, nobody ever says that. You know what?
Now, watch the contrast here. Judge Boyd moves from theft to DWI. Two different crimes, same theme, choices with ripple effects. She doesn't mince words. After your third DWI, there's no excuse left. You're not unlucky. You're dangerous. What chills me is her explanation. Nobody ever plans to kill someone drunk driving, but they do. It's preventable tragedy. She offers probation and GPS instead of jail, but make no mistake, that's mercy laced with warning. Do you think leniency here saves lives or risks another one?
That's that. You know what ends up happening? You will represent a client sometime who has gone out, had a meal, drank alcohol, is intoxicated, hits somebody, kills somebody, or injures them, and then they come to court crying about how sorry they are. So you are one of those people who cannot drink alcohol at all. And you should have learned that after the first DWI and the second DWI. And now we're here with the third.
Now I'll make one sober.
Well, congratulations. You know, it's one day at a time.
What I'm doing right now.
People, places, and things. All right.
I lost 25 pounds thanks to it.
Oh, see? Look, I don't even drink. I don't know why I got
That's
this.
not right.
It doesn't help me, but okay.
I'm looking forward to doing better.
So how are you maintaining your sobriety? What are you doing?
I'm working, and that's keep in mind on that. I work 12:30 to 9, and I don't even think about drinking.
Well, here's the thing, because at some point hopefully we all will retire and you will have free time. So you're going to have to figure out how do you maintain your sobriety when you have a lot of free time. You understand?
Yes, I hear it.
All right. The court is going to sentence you to 2 years in the prison, suspended and probated for 4 years. There's a $2,000 fine. That will be probated. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. No employment as a home health care provider or with minors. There's to be $60 restitution to DPS. All right. So with regards to DWIs statutory, you have to do 10 days in the Bexar County Jail or something else, right? So here are your choices. You can do your 10 days in the Bexar County Jail. It'll start today. Or I can keep you on GPS. And if you're going to be working, it will be partial GPS. And I'll do partial GPS for 20 days. The reason why I'm doing 20 days other than the normal 30 that I usually do is because that he's been on GPS for a while.
Thank you.
So what do you prefer?
Like GPS.
All right. There's to be 20 days partial GPS in lieu of the 10 days at Bexar County Jail. And that's for employment only. So what that means is if you're driving down the street, and you see Burger King or something, you're like, you know what? It's right next door. Let me stop there. You're not allowed to do that. You're only allowed for 20 days to go from work to home and work to home. You understand?
Yeah, that's what I've been doing.
All right. And for the record, I'm giving him the 20 days partial GPS in lieu of 10 days at the Bexar County Jail due to several reasons. One, my understanding, the fourth floor flooded. That water came down at South Tower. So there's probably mold or something behind the walls. I don't know if they dried it out yet. And there are, I'm not sure if they still have the recluse spider outbreak over there. and there is also COVID. All right. So that is why I'm not doing it. And I have to put it on the record.
Okay. We need
All
one
right.
of those three would be enough.
There's to be the VIP Live, DWI education course. State, how long did you want ignition interlock?
At least half the time.
All right, ignition interlock for half the term. 200 hours of community service restitution. So you're going to have to do 200 hours of community service restitution, or I will deduct an hour for every sober support meeting you complete. Field visits, one time per month for 6 months. Probation, is there anything else?
Oh, the GPS, that's gonna be, is that the piece of weight?
Yes.
Okay, Judge, thank you.
All right. Is there anything else you need from the court in order to be successful?
No, man.
Oh, and I'm sorry, Ms. Abrams, we can do a TAP evaluation out of custody.
Okay.
I mean, it seems that he is maintaining his sobriety, and if you could let them know, please don't let that interfere with his work. If he can do it by Zoom, great. All right, I'm sorry.
On the work on the doing my community service, will y'all send me somewhere to go do my community service?
Probation will let you know. So you have a choice. You can do the 200 hours community service restitution, which it's hot. They're probably going to have you outside picking up trash or something. Or you can work on your sobriety and do a sober support meeting. So if you were to do 200 sober support meetings, then your community service hours will be deemed satisfied. So it's up to you.
Okay.
All right. Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to your attorney. Do you understand? All right, we can go off the record. To be successful on probation in this court, communication is key. Whatever you do, do not stop reporting. Do not fall off by the wayside and we don't know where you are. If for some reason you think you're about to take a drink, pick up the phone. You can call your probation officer, and you know what they're going to tell me? Hey, he's saying that he may take a drink, and I'm going to have a compliance hearing for you to come in to see what we can do to get you past that point. You understand? But if you just disappear, you can't help somebody who disappears and won't help themselves. You understand? All right. Probation will go over conditions with you. All right. Good luck.
Thank you, Judge. Maybe excuse.
Yes. All right. Anyone else, Ray?
Yes, ma'am. Ted Kalunga, page 1, 60, I'm Judge. Judge, I'll be back.
All right. Thank you. All right. Ted Cantu Kalunga. Hello.
Hey,
Hi. Thank you for dressing appropriately for court. Well, today is your plea deadline date. So is this going to be a jury trial?
Not yet.
I mean, it is, unless you all have worked out something.
We are in the process, Judge.
Well, Judge, Mr. Bird brought some information to me on this setting about a civil suit with the victim and the defendant. And he's going to supply that information to me. I need to contact the victim on that because it seems that it would be damaging or possibly very useful for us to go forward on the case. So I don't mind setting it off for trial. If anyone, I can check that out and determine whether we're going to proceed forward with the case or not, Judge.
All right, Ms. Ferguson.
Yes, sir.
I need a jury trial date on this case.
Okay.
How long do y'all expect it to last?
I mean, if you want to trial on this, Judge, it's probably 2 days, 3 days at most.
November 12th.
All right, November 12th will be your jury trial date.
Thank you, Judge.
All right, once you sign the reset form, you excuse.
Okay.
All right, anyone else ready?
Yes, ma'am. Roxanne Gonzalez, page 1, 3 down.
Judge,
Yes.
before, I'd like to, if you don't mind, I'm introduce you to Melissa. This is going to be the next first chair of the 187th, Judge Boyd.
Hi. Nice to meet you. Nice to meet you. Well, welcome.
Well, thank you.
We are a slow running court, so normally we don't have that many cases. We're rarely in trial. But I say that with a straight face.
I think I said the exact thing.
Thank you.
You got it.
I was like, the cat's out of the bag on that. On YouTube, everybody knows.
Well, welcome to the 187.
I'm excited.
And she,
Look forward to getting to know everybody and talking to you and whenever we have time.
Okay, awesome.
but she'll be back, I think, sometime this week, either maybe tomorrow or Thursday.
Yeah, so I can get an idea of schedule and how things run. So I'll be down as soon as I can get some of my intake resolved before whenever.
All right, awesome. Well, welcome.
Thank you. It's nice to meet everybody.
Yeah.
This is everybody.
All right, yeah. All right, Roxanne Gonzalez. Okay. So where is she?
He asked me that he got in contact with her and told her to come here.
All right, Roxanne Gonzalez. All right, could you make an announcement in the hallway for Roxanne Crystal Gonzalez, please? All right, Ms. Ferguson, if you let defense counsel know that a judge's warrant is going to be issued, and if she makes an appearance, the court will reconsider. And is she out there? All right, the court is calling 2025 CR 000373 State versus Roxanne Gonzalez. This hearing was scheduled at 9 a.m. It is now 2:09 p.m. The defendant has not made an appearance. And Deputy, did you make an announcement?
Yes, Judge.
All right. And Ms. Ferguson, did the attorney let her know to be here?
Yes, ma'am.
All right, State.
Judge, we're asking for, I guess, is it a bond forfeiture or judge's warrant?
All right, the court will issue a judge's warrant. If she makes an appearance, the court will reconsider. Is there anyone else? All right, Gilbert Avalos, if you'll come forward, please. Hello. All right, so your attorney is stating that they didn't have notice today of this setting. So we're going to recall you for tomorrow. Are you employed?
No.
All right, so we're going to recall for you tomorrow. And if you'll sign the reset form, then you're excused. And thank you for dressing appropriately. All right, just stand there and they'll give you a reset form. Yes. Oh, it is, it's not a, it's usually used when for me personally, I don't want to forfeit the bond. One, because the attorney is not here. And two, sometimes maybe someone doesn't have a notice of something, and it's easier if I do a judge's form as opposed to forfeiting the bond. Because if I forfeit the bond, then sometimes the bondsman or, you know what, you've already forfeited the bond. I don't want to be on the bond anymore. And then they'd have to find another bondsman and pay again. And I don't like doing that. Anyone else?
I guess I'm page 9. First one sentence. Defense counsel is asking if we can do the call for tomorrow. They come from the daughter school. She needed to be picked up.
All right. So Deputy Laura,
Yes, sir.
if you let Mr. Ross, James Ross.
He's out here, Jim.
All right, Mr. Ross, we're going to recall you for tomorrow. Your attorney had a medical emergency, a medical family emergency. All right, anyone else ready?
Page 9, Daniel Country. Defense counsel said he did not receive notice. I don't know if this defense notice got a client.
Well, his client is listed as a fugitive. Daniel Cantu?
No,
he didn't.
His client already has a warrant.
Page 9, page 9, yeah.
All right. I mean, it's not like you do. Give yourself with the next pretty difference. Yeah. So, exactly, yeah, I'm not going to leave out the okay,
All right, anyone else?
Yes, there's 11, 6 down. Ryan Rios.
Yes.
He's here. The defense counsel is still with the.
All right, when do you want to reset it?
I can bring it back on the 15th.
All right, Ryan Rios, if you'll come forward, please.
Ryan, please get me from. Make sure attorneys come here.
All right, we're going to bring you back on September 15th. Your attorney is out ill, okay?
Okay.
Are you in school or anything?
No.
Employed?
I'm trying to get a new job.
All right. If for some reason you obtain employment before that date,
Yeah, and then I got
you can call in and we can have it. We can have you present by Zoom since it's for a restitution hearing. Okay.
Okay.
All right. Thank you.
Would I get it on?
You're gonna get a reset form.
Would I get it on email?
Your attorney will be able to give it to you.
I'm going to accept. Grab a pen, and 5 words of defendant.
All right, Norma. Who else?
I have Philip Sanchez is a police.
And that's why Judge Boyd's courtroom feels less like a sterile chamber of law and more like a mix of therapy, tough love, and real-world accountability. She exposes lies, breaks down excuses, and still manages to show flashes of humor and humanity. But the takeaway is sharp. Better decisions are the only way forward. If this case stunned you like it did us, smash that like button, comment your verdict below, and subscribe for more courtroom breakdowns every week. Justice isn't just a process, it's a story. And we're here to tell it.